This is Ian Ballin. He will do our copyright year in review presentation. His full bio is in your materials, and I'm really pleased that we have Ian to join the program. As Tasha and I were discussing, and I think I've told you this before, I have followed your CLEs like for 10 years. And so we ended up on a program together, I guess it was about 2-3 years ago, and I seized the moment, right? And I said, hey, you ever thought about coming to Washington, D.C.? And so we've had him here as a part of the program ever since.
My sister-in-law is actually a Howard alumnus, and so it's a great honor for me to be here talking about copyright law year in review. And because of the storm, I'm going to have to do it in a more compressed fashion, so I apologize if I talk too quickly. I have included excerpts from my treatise in the materials on copyright fair use and on the DMCA, which are the two main areas I'm going to talk about. This was my treatise. It was a 4-volume set last year. It became a 5-volume set. Brevity is not my strong suit, so doing this in a more compressed fashion because of the storm is going to be a challenge, but I will try to cover as much as I can. There have been a lot of developments this year and a lot of interesting things. Let me also say at the outset, because I'm a litigator, I'm in court all the time, that nothing I say represents the views of my clients, my law firm, or even myself. Anything I say is just offered to further the lofty CLE objectives of this law school and should never be quoted back to me in a brief, please. Now, with that disclaimer, I thought I'd put up on the board some of the main cases. I apologize. I realize for those of you with less than 20/20 vision, this is going to be your, not the annual year in review, but your annual vision test. I will give you a printout of these slides. It's helpful for me to see everything in context. Let me talk quickly about what I think some interesting cases and then get into DMCA and fair use. The Supreme Court had a new case this past year, and that dealt with the copyrightability of cheerleader outfits. And that is an interesting case. It doesn't come up all the time. And the court found that actually the cheerleader outfits were copyrightable. But the key point is it was the artistic contribution. It was not the outfit itself. If you know, this is copyright law. This is for liberal arts people like me. The smart people with science degrees, they're patent lawyers. They figure out how to protect the IP on things like outfits or whatever. It's got to be artistic or have some creative component. And so the Supreme Court made very clear that the only feature of the cheerleading uniform eligible for copyright was the two-dimensional work of art fixed in the tangible medium. And they said that if that artistic design would be entitled to a copyright, if it were a painting or a drawing, then it's still entitled to a copyright on a uniform. So it's a narrow holding. It doesn't mean that that suddenly all forms of clothing are going to be subject to copyright protection. The other Supreme Court case, it's really not from last year, it's the year before, but it's a trend I wanted to flag that I think is quite interesting, and that is that the current court, the Roberts Court, seems to be merging the standards for attorney's fees between copyright, patent, and trademark law, and I think that's an interesting phenomenon. A couple of years ago in a patent case, Octane Fitness, the Supreme Court said, well, let's look to the Fogarty case, which was the seminal case construing copyright attorney's fees, different provision under the law. Under Title 17, the grounds for attorney's fees are different than they are under the Patent or Lanham Act. Nonetheless, the court said, look to the Fogarty factors. It's discretionary. Just because you win a copyright case, either as a plaintiff or as a defendant, it's not automatic that you will recover fees. But Fogarty listed a number of factors. And then more recently in the Kertzing case, the Supreme Court said, look to objective reasonableness. The Fogarty factors are important, but whether a case is objectively unreasonable or objectively reasonable is an important factor to consider. And so there is this merging, in a way, of copyright, patent, and trademark. And I think what that means is, for all copyright cases coming to the Supreme Court is going to look to patent law and trademark law, even when the language of the statute is different, and that's an important point. In the past year, we also had the First Circuit Court decision construing the Family Movie Act. It may also be the last Circuit Court decision, because there's not a lot of litigation under the Family Movie Act. It's a very narrow statute that allows, it created an exception to the exclusive right of a copyright owner to allow certain content to be omitted by viewers in private households. The idea is that adult language could be edited out by families. And I have small children. My daughter's 5, my son is 2, and it is very challenging trying to watch movies because even kids' movies have content that's challenging. We tend to watch Bollywood films because, it always ends in a song and dance, and for little kids, that's a good thing. So I understand the concept of the Family Movie Act, even though, of course, from an artistic standpoint, the creators of movies don't want their works to be altered. So it was a delicate balance that Congress created, and it allows people in their homes to edit these films, and it allows companies to provide technology, such as software, to edit these films. What it doesn't allow is for people to make family-friendly versions of the movie and sell or rent them. And that's essentially what happened in this case, Disney v. VidAngel. The Ninth Circuit ruled in favor of Disney. VidAngel had, what it did is they created family-friendly versions of movies, and then they sold them, and I use quotation marks around the sale. They sold them, to their customers with a buyback program that effectively meant they were renting the movies for $2. And that was the first thing that just didn't look right about this case. The motion picture studio plaintiffs also presented evidence that about half of the VidAngel subscribers said they would have subscribed to the service anyway, even if they had not had these family-friendly features. So in reality, it was a movie rental service where royalties were not going to the motion picture companies, and the use was unlicensed. The circuit said that this was not permissible under the Family Movie Act. It also was not fair use, and as a consequence, the server copies that were created when this company went out and bought lawful copies of motion pictures on DVD, that when they then took that content and put it on the server, that likely constituted a violation of the anti-circumvention provisions of the Digital Millennium Copyright Act. So an interesting decision. Registration. I'll say a little bit more about that at the end of the program if I'm able to talk quickly enough to get to it, which I hope I will. But there is a split in the circuits right now. It's an interesting question about whether you need to have a registration certificate on file to bring a copyright suit. That is what the 11th Circuit said you must do, or whether you simply need to have filed an application, which is what the 9th Circuit previously said you had to do. And the U.S. Supreme Court in January of this year asked the Solicitor General to weigh in on whether the court should grant cert. So it may well be that we'll have a decision on that issue. Statutory standing to sue. There's an interesting case from the 9th Circuit, DRK Photo v. McGraw-Hill. And one of the reasons it's interesting is a lot of litigation that I'm seeing in my practice involves photographers. There's been a lot of effort by photographers and their various trade associations to encourage members to register copyrights and to file suits, and there are a lot of lawyers that are willing to take these cases on contingency or on the hope that they might get attorney's fees. These are probably former patent lawyers displaced by some of the changes that you heard about earlier this morning in the patent law year in review, but there's certainly been an uptick in suits by photographers. But the interesting thing is that a stock photography agency, which really acts as the agent for a lot of the photographers, does not have standing to sue unless they are the exclusive licensee or owner. And the Copyright Act is very clear. To sue, you have to be an owner or an exclusive licensee. A non-exclusive licensee cannot sue, and a stock photo agency cannot sue. In the copyright software area, there are a couple of interesting issues. One of them, of course, is the Oracle v. Google case before the Federal Circuit. I can't really talk about that because I represented Google along with other law firms at the district court level, but that's going to be an interesting opinion coming out. The other interesting software issue is to what extent can the output of a copyrighted software program be claimed by the copyright owner as part of their work. And the reason that is getting more traction these days is because the Ninth Circuit, my home circuit in California where I practice, suggested last year in Design Data Corp v. Unigate Entertainment that there are circumstances where the output of a software program could be claimed by the copyright owner either as part of the copyrighted work or as a derivative work. And that's interesting. It's an aggressive view. The Ninth Circuit ruled for the defendant in that case, but they conceded that this was a possibility. And that really opens up and encourages further litigation. And indeed, just in the past week or so in the Northern District of California, the court rejected a claim by Reardon against Motion Picture Studios, alleging that the output of their special effects software, various scenes in movies, belonged to Reardon. And the court said, that is not the case. But based on this Ninth Circuit law, the judge acknowledged that there may be circumstances where the output of a software program could be the copyright owner's work if it does the lion's share of the work. And that really is the Ninth Circuit standard. There's a much older Southern District of New York case from the 1990s that also suggested that. It's a narrow area, but as is so often the case in the law and litigation, when a circuit court suggests there may be a claim, lawyers will rush in to try to make it. So I think we're going to see more of that issue, and it's certainly an interesting one. Geophysical Service v. TGS, another case from last year, this time from the Fifth Circuit, was an interesting one just in serving as a reminder that copyright infringement is not just reproduction, distribution, the bundle of rights that we all know about under the Copyright Act, but also import or export. This was a case that involved infringement that occurred exclusively in Canada, and the defendant was sued in the United States, and the defendant said, whatever we did in Canada. But to the extent the product was imported into the United States, the act of importing a product that, if made here, would be infringing, constitutes a violation of the Copyright Act. So it is an important reminder. Another interesting case that I thought I would bring up from just a couple of weeks ago from the Southern District of New York involves the issue of inline links. And I thought it's an interesting case because it involved an embedded video in a Twitter feed. Now, the reality is that linking is the way the internet operates. Linking is the way social media works. We all link. Probably several of you have created links while you're working on your phone at points in the presentation that were of less interest to you. Linking is just what we do. And so it's an interesting case because in Goldman v. Breitbart News, the plaintiff, who is a copyright owner of a photograph of the football player Tom Brady, sued Breitbart alleging infringement because Breitbart had an inline link to that photo, and the court found in granting partial summary judgment that the inline link created a public display. Now, it's an unreported opinion, and it's from the Southern District of New York, but I think it's worth discussing because this whole question of links, many people thought was quite settled. More than 10 years ago, the Ninth Circuit in the Amazon v. Perfect 10 case said that a link is simply an instruction to a browser to go from one location to another. And you look to see what server is the material actually copied on, and that server may be held liable for copyright infringement, but a link to that server is just an instruction to a browser to go to one location or another. Now, an inline link is a link that doesn't just show the URL, but actually displays the photo. So an inline link in a Twitter feed, you see the photo, but the photo was not coming from Goldman. The photo was coming from this other website. The issue, which I think some people have missed in talking about this case and about inline links, is that the Perfect 10 case talked about reproduction and distribution, but not public performance or public display. And those were more open questions. There is an unreported decision from the Southern District of Texas from a number of years ago where there was an inline link to a live concert. And the court there also said, well, that's a public performance. So the interesting aspect of this case is, because this was a photo, the court said this is an unauthorized public display of a photo. I do think that there's potentially a difference between reproduction and distribution. I think from a policy standpoint, I probably would have decided the case differently, even though that would have meant I would have sided with Breitbart News, which I would never cite with Breitbart, so this would be unprecedented. But at least from a legal perspective, I think there would be a good argument that a link is just an instruction to a browser, and even a public display wouldn't be created because it's just an inline link. But I do think that at least the district courts seem to be distinguishing public performance, public display from distribution and reproduction, and that's something that will eventually need to get sorted out by the circuit courts. The final issue that I wanted to put up on this slide of a random tour of 2017 issues deals with retransmission of copyrighted television, and this is Fox Television v. Arrow Killer, also from the Ninth Circuit. Arrow Killer was one of a number of services that decided to make free over-the-air television transmissions available on a subscription basis to users over the internet. The signals are free. You could, in the old days, you could set up an antenna. Now, since I don't watch television on televisions anymore, I'm not sure what one would do technically, because I look at if I watch anything, it's on my phone or computer. But I think there are digital antennas or other ways that you would connect. But these are free over-the-air signals, and courts have uniformly held that even though the signals are free, when a company comes in and takes them and retransmits them, that is copyright infringement and not fair use. And so Arrow Killer said, well, that's fine, but then we're entitled to a compulsory cable license, and the district court agreed. And the Ninth Circuit said, not really, because if you look at the language of the statute, they're really talking about cable companies, not companies that just happen to be retransmitting television. So that essentially kills Arrow Killer, and that's the end of that. But it's an interesting decision. So let me turn to secondary liability. I want to try to drill down on secondary liability and then a little bit on fair use. And in secondary liability, this issue comes up a lot for liability of platforms. And again, I apologize, that's another eye test slide for you, but I will be happy to give you a printout of the slides. Secondary liability is important for platforms. And platforms, in the olden days, we talked about service provider liability, and we thought about ISPs. Today, we're really talking about a much broader range of companies. Social networks, cloud storage providers, app stores, websites. Corporate website may have interactive components, and a range of different companies. And so these issues are quite important. And indeed, even many content owners are also either service providers or platform providers. We also see a lot of e-commerce companies act as platform providers. because I know copyright is a rarefied area of intellectual property, I happen to think it's pretty interesting, but I know in this conference there are more patent lawyers and probably even more trademark lawyers. I thought it'd be helpful to put up a comparison of copyright, trademark, and patent. In the copyright area, there are different theories of secondary liability, and there's the Digital Millennium Copyright Act, which everybody knows creates a notice and takedown system. Even non-lawyers know that. There is no corollary under the Lanham Act. There's no Digital Millennium Trademark Act. But courts have largely incorporated, through case law, the notice and takedown mechanisms of the DMCA, starting first with Tiffany v. eBay in the Second Circuit, following that, the 10th Circuit in 1-800-CONTACTS, also the 4th Circuit in a case involving Google, and numerous district courts have held that it's not enough that something is posted on a site or available on a platform. There has to be knowledge. And the best way for a plaintiff to at least create a fact question about knowledge is to send notice. Now, parenthetically, and I've argued this, notice is not necessarily the same thing as knowledge, because when you're dealing with trademark law, the metes and bounds of a trademark may expand or contract over the life of the trademark, based not only on the trademark owner's use, but third-party uses, and it's not at all clear to a given platform provider whether a plaintiff in some cases actually has those rights. But you have to at least have notice. That's what most courts say. We see more recently in these more recent district court cases I mentioned that this issue can be decided even on summary judgment. There even was a district court case deciding it on a motion to dismiss. And so it's becoming more understood. Tiffany v. eBay was decided after trial, and now courts are getting more comfortable with this notion that if there's no notice, there's no secondary liability for a platform under the Lanham Act. In the area of patent law, obviously patent law is quite different, but there also are suits against platform providers. And in the past year, in a case where I represented eBay, Blazer v. eBay, the Northern District of Alabama held that simply because eBay operated a platform where users offered for sale particular devices did not mean that eBay itself was either selling or offering for sale the good, and therefore there was no claim for patent infringement, summary judgment granted. Amazon also prevailed, although not on that theory, but on an analogous theory, in a secondary liability claim. And again, this is important because for platforms, the platforms typically don't want to have to respond by taking down user offerings or user material every time they get a patent notice. In fact, I noticed that Professor Lemley from Stanford and a couple of others recently published an article that documented that only a very small percentage of non-operating company patent owners actually end up prevailing in those cases that go to trial. It's a very small number. So simply the assertion of patent infringement is not the same as infringement. But I digress. Copyright lawyers should not talk about patent law. So let me get back to things that I actually know much better, which is copyright law. And in the copyright area, there have been really two big DMCA decisions. And one of them I put up here, and then to make it a little more confusing, I then have a section on DMCA where I talk about it, but I apologize for that confusion. The interesting issue, the DMCA, as you know, it's notice and takedown. There was an important decision in 2016 out of the Second Circuit that says when a service provider makes a prima facie showing of entitlement to DMCA protection, the burden of proof shifts back to the copyright owner to show that the service provider is not entitled to protection based on something such as knowledge or red flag awareness. That's an incredibly important opinion because in a lot of these big cases, there isn't evidence. The plaintiff seeks everything that's on the server and then pulls out a bunch of things and says, these are infringing. And then the question is, did anyone at the service know about that? Because unless the plaintiff can show that someone actually knew it was there, then there's no knowledge or awareness, and the defendant still has service provider protection. So the shifting burden of proof is quite an important one. And Part of the reason is because a service provider loses safe harbor protection if they have actual knowledge of infringement and ignore it, or red flag awareness, which is awareness of facts or circumstances from which infringing activity is apparent, this notion of material that raises a red flag. And that's judged by an objective standard. And that's really quite difficult. For example, if you're running a music service and you have reviewers that are trying their best to keep material off the site. If you've got a reviewer, who's a country western fan, and there's an Azalea Banks song that comes on, the country western fan may not recognize it. Good faith. Subjective good faith thought it wasn't infringement, but subjective good faith doesn't help you because red flag awareness is judged by an objective standard. So the challenge in a lot of these cases for copyright owners is proving that someone actually saw the material. Now, in that context, the Mavericks Photographs Be Live Journal case from 2017 is extremely important. I think it is wrongly decided, but we'll see what my opinion means. I've noted that in the 2018 edition of my treatise, and I'll tell you why I think it's wrongly decided. Mavericks was a suit against LiveJournal, where LiveJournal uses community reviewers, volunteers, to review every post. Now, that should be a good thing. You would want people to review material so that if there's something infringing, you keep it off. If there's something offensive, you keep it off. From a policy standpoint, you'd want to encourage it. Because everything was reviewed before it went up on the site, the Ninth Circuit said that created a factual question about whether the material was actually stored at the direction of a user or was stored by the reviewer, in which case it's not even entitled to safe harbor protection. Now that's really a landmark decision. The reason I think it's wrong is because if you look at the language of the statute applies to material stored at the direction of a user, not stored by a user. And so if I, as a user, try to upload something, it's reviewed by you as a reviewer, and then you approve it and it gets uploaded, it's still stored at my direction. And the statute talks about material stored at the direction of a user. The Ninth Circuit doesn't get into that distinction, but that's why I think it's wrongly decided. Nevertheless, it creates a real issue for a lot of platforms in today's world. The other thing about that case that creates a problem is if you run a service and every piece of content is reviewed, it makes it a lot easier for a copyright owner in litigation to establish that you're not entitled to DMCA protection. Why? Because it goes back to the example I gave of the country western fan who misses the Azalea Banks song. And it's because red flag awareness is judged by an objective standard. And if you review everything, then the plaintiff has evidence that you saw it. And so if objectively something is missed in good faith, you're outside the safe harbor. So this case suggests a few things. First of all, it suggests that pre-upload review is dangerous because under this Ninth Circuit case, if it's reviewed first, it may not even be within the safe harbor. And second of all, it suggests that if you're going to do review, it's now dangerous to review everything. So if you even post upload review, if you review every single thing, then you may end up losing safe harbor protection. So I think it's a bad decision, it's bad policy, but who am I to say that? So let me turn, because I know I'm low on time. Let me mention another DMCA case and then say a quick word about fair use. Another DMCA case, very important decision, just issued about 2 weeks ago, BMG v. Cox Communications. That was actually decided by Judge Liam O'Grady, and Liam and I became partners at Finnegan Henderson back in the 1990s when I was at that firm, and he was at that firm in the same year, and now he's gone on to be a lofty judge, and I'm still billing clients by the hour. So he's a much smarter man than I am. He decided that case in the district court. It went up to the Fourth Circuit, and on the DMCA issue, the Fourth Circuit affirmed. Cox Communications was found not entitled to DMCA protection because one of the requirements of the DMCA is that you have a policy of terminating repeat infringers in appropriate circumstances and reasonably implement that policy. And district courts have largely upheld a three strikes policy, mainly because Americans like baseball. And no judge or jury is ever going to say 3 strikes is unfair. I mean, repeat infringer really means someone that's been tagged at least once. You could make an argument that the second time you're a repeat infringer, but we love baseball, so 3 strikes seems to be fair. Now, Cox had they actually had a 14-strike policy. That's not baseball. That starts to look like cricket. And American judges and juries just are not going to put up with cricket. That's just unreasonable. Now, in fairness to Cox, they had a graduated response policy. And actually, by contract, a number of motion picture companies and other major content owners have agreed with a number of major ISPs to a 6-strike graduated response policy. The theory being that your home internet account is a lot more important than access to a website, and therefore they're not going to do 3 strikes, but it's going to be graduated response. You'll get notices, you'll get blocked from getting in. The idea, and actually the statistics bear this out, that a lot of users who are tagged as infringers, make a mistake, they don't know what's going on, or their kids are doing things that they get punished for, but then they stop doing. And so the 6-strike policy works well. But 14 strikes is not good at all. Plus, there were bad emails that talked about how much money the company lost per subscriber. So that doesn't look good at all. So let me finish up with a word or two about fair use, because actually, one last DMCA case. Epic v. Mendez is a counter notice case. Very interesting. That rarely gets litigated, but under the DMCA, if you send in a notice, the material comes down. If the user challenges that and under penalty of perjury submits a counter notice saying, wait a second, I own it, or I'm licensed, or it's fair use, then the material goes back on the internet unless the copyright owner files a lawsuit within 10 days. And to serve a counter notice, you have to agree to service. And in this case, what happened was you had infringers in Russia. They agreed to service, but Russia doesn't adhere to international treaties these days, and so even though they are a member of the Hague Convention, they will not enforce U.S. subpoenas. District Court approved substitute service by email saying, they agreed to accept it, they provided an email address, this is good enough. So something interesting to keep in mind. So a quick word or two about fair use, and in fact, actually, it's a multi-part balancing test. There's some very important parts about it, but we're running late and we've got lunch, so look at the materials. and let me instead go to copyright cases to watch, where there was an interesting fair use decision. When I put these slides together earlier this week, because I try to wait as much as possible to the last minute, because there are always breaking developments, one of the things I said to watch for was Fox News v. TV Eyes, because it's before the Second Circuit. Well, 2 days ago, the Second Circuit, knowing that this conference would be held at Howard, decided to make it more interesting by deciding the Fox v. TV Eyes case. And since I've been in depositions in New York this week, it's even more challenging to actually come up to speed on it. But I did. And it's an interesting decision. The court held that TV Eyes was not entitled to the fair use defense. What TV Eyes had is an interesting service. They indexed all Fox News programming and then created a great search tool. So if you wanted to find out something that was on Fox, you could use this search tool, and then you'd get a 10-minute clip, and you wouldn't have to watch Fox News 24 hours a day to find that clip, which could be bad for your health. And, no one can watch Fox News that much. Except the president can. But most of us who have day jobs, we can't watch Fox News, that long. So it's an interesting tool, and it was an interesting case because that seems transformative. To create a search tool like that is actually quite useful. On the other hand, is that fair use? Because you're taking all of the Fox content, you're indexing it. So everybody argued that the Google Books case was on point. And in Google Books, Google copied millions of books without authorization, created a search tool, and the Second Circuit said it's highly transformative. But in the Google books case, you couldn't get the whole book if the book was commercially available without the permission of the owner. What you got were little snippets and excerpts, so it really was a research tool. And Google had gone to great lengths to make sure you couldn't, sort of get the whole book by using the service over and over and over again. Here, on the other hand, you got the 10-minute excerpt you wanted and nothing else. So the Second Circuit, in a very interesting decision, said this is somewhat transformative, but it has an adverse impact on the market for the genuine product. This service competes with Fox, which also sells clips, and therefore it's not fair use. So very, very interesting decision. The final thing I want to just say, and I alluded to it earlier, is the Supreme Court going to take cert on this issue of is registration required? A lot of this confusion comes from the Reed Elsevier v. Muchnick case, which actually was decided 8 years ago today. And this is one of the great things about social media. Muchnick was the only case I've ever had that went to the U.S. Supreme Court, and the reason that I knew the decision came out 8 years ago today is because of social media. I got a handy reminder this morning that 8 years ago today I posted that my client had just won this great case. So thank goodness for social media. But in Muchnick, the court said that the requirement for registration is not jurisdictional, which was great because we got a 9-0 reversal and it went back to the Second Circuit. Incidentally, we're still litigating that case. I do believe that in 2018 it'll be over, although I have said that earlier in 2017, 16, 15, 14, 13, 12, and 11. But I do think this will be the year. But putting that aside, but the court said it's mandatory but not jurisdictional. So we now have a circuit split where courts are saying something different. In the Petrella v. MGM case, there's very significant dicta where the Supreme Court said although registration is permissive, both the certificate and the original work must be on file with the Copyright Office before a copyright owner can sue for infringement. And that's influential dicta. How is the court going to rule? And it's an interesting one. Stay tuned. In January, the Supreme Court asked the Solicitor General to weigh in whether cert should be granted. Right now, plaintiffs like to sue in my home circuit, the Ninth Circuit, because all you need to do is apply. You don't need an actual registration. So there's an interesting diversity. Southern District of New York had a case last year where a judge said, okay, there's no certificate. I'm not going to dismiss the case. I'm going to stay the case, and plaintiff, you have 60 days, and if you can't get it, I'll dismiss it. And of course, they couldn't get it in 60 days, so it ended up working out okay. On that high note, let me end there. There are some other slides. Happy to give you a set of the slides. Ask me at the lunch or this afternoon, or email me or contact me on social media. Thanks so much. It's an honor to be here.